Hey guys, welcome to this video. My name is John Watts. If you're interested in the CARES Act, that's the law that is in response to the COVID-19. And if you're interested in credit reporting, then this video may be of some interest to you. So this is a letter that I have on the screen from April 13 from the Attorney General of Pennsylvania. Then a bunch of other states have signed on to it. And it's written to the director of the CFPB, Consumer Financial Protection Bureau. And there's really a couple things here. And I want us to look at this, and then we'll look at the actual announcement from the CFPB, because I think this letter that we're looking at right now has definitely some good points to it. I think it maybe misunderstands what the CFPB has said. And so look down here. We've got the Attorney General saying, we oppose your recent announcement suggesting, number one, the CFPB will not enforce CARES Act's amendment to the Fair Credit Reporting Act that requires lenders to report as current any loans that are subject to COVID-19 related forbearance or other accommodation. I think that's actually incorrect. I don't think that's what CFPB is saying, but we'll look at that. And then number two, and this is an interesting thing that's caused a lot of concern among consumers, among credit repair agencies, and that is that CFPB will no longer take enforcement or supervisory actions against consumer reporting agencies. That's going to be like Equifax, Experian, TransUnion, when they fail to investigate consumer disputes in a timely fashion. Now, there are some caveats to that, okay? But the CFPB has said that they will allow the bureaus and furnishers to go beyond the time limits, but that does not change what the law actually says. Okay, so we have to distinguish between what the CFPB may be able to do to somebody as an agency, and what we can do, for example, to Equifax, Experian, TransUnion under the law in state or federal court. So we've got this first part here. It says, announcement that will step back from enforcing the CARES Act requirements could discourage consumers from taking advantage of forbearance. So the deal with the CARES Act is, if you were current when you receive a forbearance, let's say you have the forbearance for 6 months, then the furnisher, so that's your mortgage company, they have to report you as being current even though you're not making payments for 6 months. And so this letter from the Attorney General is saying to the CFPB, you can't say to companies, oh, we won't enforce this. Again, that's not actually what CFPB said. But this is what the Attorney General is at least reading into that. And maybe there have been private discussions about this. So they say, look, you're going to discourage consumers from taking advantage of the forbearance if they can be reported as late. Now, remember this. You have to have been current going into the forbearance. If you were 30 days late and then you get your forbearance, you'll be reported as 30 days late all the way through. Okay, so you have to be current. And the Attorney General letter here says, if you allow companies to report negative when they're supposed to report positive, that puts the lenders that follow the law at a competitive disadvantage. And that certainly is true. And then second, they say, allowing the credit bureaus to ignore the 30-day timeline to investigate disputes puts consumers at risk, because this is a time where we really need to have accurate information on our credit. And let's see here. We'll just look at this. CARES Act provides critical protections to consumers to enable them to weather this period of economic turbulence without incurring lasting harm to their credit scores. It provides a 180 to 360 day grace period for homeowners with federally backed mortgages. So just to be clear, it's a forbearance that says you don't have to make your payments. Now, that money is still owed once you're done with the forbearance, and I'll talk about that in another video. It says borrowers with these loans do not have to make payments, and lenders are prohibited from furnishing negative credit information on these skipped payments. Again, that's not actually accurate. Whatever your state is going into the forbearance is what the furnisher must report on you all the way through the forbearance. So if you were late going in, you're reported as late. That's negative. And so anyway, the letter goes on to talk about their scams and, we need you to follow the law. And I do like this. They say CRAs have only one job: maintain accurate credit reports. Now is not the time to let them fall asleep at the switch. Yeah, that's absolutely right. They must be vigilant and protect consumers' credit, especially during this crisis. We must hold them accountable when they fail to respond to and correct errors on credit reports. And it says even if CFPB refuses to act, we will enforce these rules. And certainly consumers can enforce the rules. So that's the letter. Now, here's why I say that the letter is a little bit inaccurate. If we go to the announcement from the CFPB, and this is what's quoted or linked to in the Attorney General letter, if you go to a footnote, I think it's footnote 2. And so here's where we come to it. It's this section right here. So let me just highlight this whole thing. They say the Bureau reiterates its prior guidance, encouraging institutions to work with borrowers. And then it says, while companies generally are not legally obligated to furnish information to consumer reporting agencies, and that's absolutely true, there's no requirement. But if you do report, it must be accurate. It says the Bureau encourages them to continue furnishing information despite the current crisis. Providing accurate information produces substantial benefits. Now, if you just had that, you might say, well, it kind of sounds like they're saying, yeah, the person had a forbearance, but they really didn't make their payment in May and June and July, so report them as late. But let's go on and see what they actually say here. It says the CARES Act, a section of which amends the FCRA, generally requires furnishers to report as current certain credit obligations for which furnishers make payment accommodations. And the Bureau expects furnishers to comply with the CARES Act and will work with furnishers as needed to help them. So, again, contrary to the Attorney General letter, the CFPB is not saying, hey, just skip the law. Don't worry about that CARES Act. They're not saying that. They're saying, we want you to follow it. We expect you to follow it. Now, then they say, look, there's all sorts of relief you may be providing, and such payment accommodations will avoid the reporting of delinquencies. The Bureau supports the efforts, voluntary efforts provide payment relief, does not intend to cite examinations or take enforcement actions against those who furnish information to the consumer reporting agencies that accurately reflect the payment relief measures they're employing. Now, if you read that, and this may be where the Attorney General is coming from, if you read that to say accurately reflect what's going on, well then, is that telling the furnishers you can report somebody as being late even though they're in forbearance and they came into forbearance as current? I don't think that's what it's saying. But if it is, then it's absolutely wrong. Okay. So the point is, no matter what the CFPB says, and they've got a lot of power, but they do not write the law. Okay. Congress has said to a furnisher, if somebody takes a forbearance and they were current, you must report them as current all through the forbearance, even though they're not making payments. You have to put in there, paid as agreed, never late, whatever the situation might be. Now, this is the part where we see the CFPB really turning against consumers here. So under dispute. So let's look at this carefully because we'll kind of see what they're suggesting to the credit bureaus here. They say, look, the FCRA generally requires the agencies and furnishers investigate disputes within 30 days of receipt of consumers' dispute. So you send a dispute to the credit bureau, they've got 30 days to investigate, including going to the furnisher of the information. That would be like Chase or a debt collector, whoever it is. But there's 30 days total. And then they say, well, that can actually be extended to 45 days if the consumer provides additional information during that 30-day period, which makes sense. In other words, if I do a dispute and it's received on April 1st, and then on April 20th, I give the credit bureau more information, well, they should have some extra time to be able to investigate that extra information. Now, I don't want to make this too detailed with the Credit Reporting Act because we can do that in another video. But you can do a direct dispute to the furnisher, and they have an obligation. The problem is you have no right to sue them under that. So here's where we start to see the CFPB get a little bit squirrely here. So let me get this first sentence highlighted. The Bureau is aware Some consumer reporting agencies and furnishers may face significant operational disruptions, pose challenges for them. For example, maybe reductions in staff, difficulty in taking access necessary information, and they say rendering them unable to investigate consumer reporting disputes within the timeframes the FCRA requires. Well, let's just stop there for a second. So let's assume the Bureau is telling the truth here. And Equifax, Experian, TransUnion, because of disruption, they just can't process disputes within 30 days. Okay, then they need to stop providing credit reports for people. You see, you don't get to provide credit reports and then say, yeah, but I can still do that. I'm keeping all my resources to making money by providing reports to companies, but we're going to have no staff to do investigations. No. If you can't do the investigations, then don't provide the credit reports. And see, the credit bureaus want it both ways. They want to say, oh yeah, we're still in business. We're still making all this money. We're still charging all these people. But now when it comes to investigations, oh, we don't have anybody. Sorry. No, that doesn't fly. But the bureau's kind of giving them a pass here. And they say in evaluating compliance, then we'll look at your good faith efforts. If we're doing an examination on you. In other words, we're not going to punish you if you go over the time limit. And so a lot of consumers, credit repair organizations were kind of freaking out about this, saying, oh my goodness, now they don't have to investigate our disputes. Look, this guidance here means nothing with the Fair Credit Reporting Act as far as the consumer is concerned. There's no change in the law that says, oh, they suddenly get 60 days or 90 days. I remember this probably 15 years ago, maybe more. I sued a company and they did not respond to the investigation. I mean, we did dispute. Credit bureau sent it to this debt collector. Debt collector did not respond in time. And I sued them. And they said, well, it's just unreasonable to only give us 30 days. We need at least 90 days. And I just started laughing. And I had the general counsel on the phone. She's like, why are you laughing? I said, take that up with Congress. She goes, no, John, you can't just say that we have 30 days. I'm like, I didn't say that. Congress did. And she was just stunned by that. And, they ended up paying us very nice money for that. But the CFPB can make all these things, oh, we understand and we're going to be gentle with you. That means nothing when you sue the credit bureaus or the furnishers for violating the law. Now, here's where we really see where the Bureau's coming from, that they are not in favor of consumers. The Bureau reminds furnishers and consumer reporting agencies they may take advantage of statutory and regulatory provisions that eliminate the obligation to investigate disputes submitted by credit repair organizations and disputes they reasonably determine to be frivolous or irrelevant. First of all, that is not the law. That is incorrect. A furnisher who receives a direct dispute from a credit repair organization can decide not to investigate. So that part is true. The credit bureaus cannot do that. And there's this misconception. And of course, credit bureaus love to do this because they hate credit repair organizations. They say, if we find that it's from a credit repair organization, we have no obligation to investigate. Absolutely false. They must investigate if the dispute came from the consumer or on behalf of the consumer. Okay? So just because a credit repair place, whether that's a non-lawyer, whether that's a lawyer, it doesn't matter. If the credit repair organization has been asked by the consumer to send the letter on their behalf, then that's fine. And the credit bureau must investigate unless it deems it to be frivolous. But if it deems it to be frivolous, it has to tell you within 5 days, hey, this is frivolous, we're not investigating it. See, what the credit bureaus want to do is say, well, we can just ignore it. And so you read this sentence, let's go through it again. Furnishers and credit reporting agencies, consumer reporting agencies, they may take advantage of statutory regulatory provisions that eliminate the obligation to investigate disputes submitted by credit repair organizations. Again, that's only half true. That is true of furnishers, but look, you have no claim anyway if you do a direct dispute to a furnisher. You have to go through the credit bureaus. Now, we talked about this in other videos. If it's a debt collector, you can make that direct dispute to them and you have the FDCPA. But for everybody else, we've got to go through the credit bureaus. And then this talks about, we'll consider whether that determination was reasonable. Again, that's from the CFPB standpoint. I don't really care about that. If they deem my dispute as being frivolous, they better be right in it. If they're wrong, then they get hammered for that. And they can't go, well, the CFPB told me that I should be like very generous with deciding things are frivolous. No, I don't care what CFPB said. That does not change the law. And when I'm in front of a federal judge, the CFPB doesn't matter. Okay. So I understand the 23, I always wonder how you say it. Is it attorneys general or 23 attorney generals? Attorney general sounds better, but I think it's actually like the attorneys general. So there were like 23 of them that signed that letter we looked at before. I get where they're coming from because the CFPB is certainly trying to send signals here that they are very much on the side of the credit bureaus and the furnishers. But again, this letter does not quite say that they get to ignore the CARES Act. Instead, it says, we expect you to comply with the CARES Act. Okay. And on the, taking more than 30 days to investigate, look, if you do a dispute, it's received on April 1st and it's May 15 and the credit bureau hasn't responded, then you could dispute again, or you may just sue them. So you did a lousy investigation. You did no investigation. And they can't go, well, we were short-staffed. Because again, if they're going to be in the game of providing credit reports, then they have to be in the game to handle disputes. They can't say, well, we got one guy who works part-time from home handling all the disputes, but we have our full staff making sure we're out there selling credit monitoring, identity theft protection, and charging the big banks and furnishers a ton of money. And no, it doesn't work that way. And so we definitely see the CFPB here is leaning towards them, but it doesn't matter. And here's the other thing. Look at this part right here. This is a non-binding general statement of policy articulating considerations relevant to the Bureau's exercise of its supervisory and enforcement authority. It means nothing, okay? And they say, because this means nothing, we don't have to, have a bunch of kind of hearings and things like that. We just were able to go ahead and do this. So I hope that that's interesting to you and helpful to you. We're going to be talking a lot more about this CARES Act and the credit reporting and getting forbearance and what that means and what you can do. What are some strategies? So just think about this for a second. So I'm recording this on April 16. Let's say my mortgage is due on April the 1st. And I'm wondering what I should do because I haven't paid it yet. Should I get a forbearance or what should I do? Well, if I'm rolling up to, let's say it's April 28th and I say, you know what? I mean, I could pay it, but man, it'd sure be nice to have 6 or 12 months of not having to pay anything. And if I can't get that forbearance in before I'm 30 days late, that's going to be a problem. And technically, it talks about if you're current, okay, which would seem to imply that you've paid the current month. So you may want to pay the current month you're in and then get the forbearance so that when you roll into that forbearance, you are current. Just something to think about. And look, a lot of the stuff with the CARES Act, there's going to be all sorts of different views. And I'm just telling you, the mortgage servicing companies will completely and utterly mess this up. They are going to mess this up so bad. There's going to be an explosion of litigation. And you've got to watch them. You've got to protect yourself. Well, look, I'll get into that in some other videos. I'll bring this one to a close. Thanks for watching this. If you need us, my name is John Watts, 205-879-2447 or alabamaconsumer.com. And I will see you guys in the next video. Thanks a lot. Bye-bye.